and the European Union, currently there are about 60 different minority groups and many regional languages spoken by about 40 to 45 million people, Basque, Catalan, Frisian, etc., Welsh. But the European Union does not provide any assistance for the protection of these languages, and this is not the only problem, this insensitivity. So I'd like to now ask Dr. Zoltan Lomnici, Jr., who is a constitutionalist and also the spokesman of TÜV. Now, about Brussels' unlawful actions and about the decisions and the room to maneuver for the member states is my topic for today's conference. And it is really obvious that in respect of this topic, we have to review of how the European Union's decision-making process is done and whether the sovereignty of the member states and room to maneuver is still established by the member states. Now, our constitution states that Hungary exercises certain rights together with the European Union. So, for instance, the budget for 2021-27, and we all know of the debates which go in the direction, or at least they're trying to push us in the direction of having, instead of unanimity, to have a qualified majority decision in the new Europe by the newly elected member countries, or the new member countries or smaller member countries, to have be pushed in the background. So our civilian organization has put forward many different recommendations which would solve the problems which currently are not only about restriction of the room to maneuver, but also the initiatives for legislation of the citizens of Europe could be more efficient. Now, this renewal could include the ombudsman, European ombudsman, and also the ability to go directly to the European Court of Justice in respect of different legal disadvantages that they suffer. So the renewal of institutions initiative is continuously happening with the assistance of civil cooperation. Now, a symbol of going against Brussels was the initiative of asking the question whether people want to be in a community where there is an absolution, they get commands, and any requests from the member countries are not accepted. David Cameron brought the attention to this before the referendum, which should have been considered. These were not considered. And then the outcome, Brexit, took place. So they said goodbye to the European Union. We also have to know that the constitutional courts could have a very important role. Now, András Varga, previous constitutionalist, I want to refer to. So there was a parallel explanation that obviously none of the member states have given up their sovereignty, and there are certain limitations to joint exercising of legal rights. So only in two cases can the European Union say that a decision cannot be implemented. directly in having an effect in a member state. So if it's an indirect effect in a member state, so that's a secondary effect, with the exceptions where an amendment to a basic ruling. For instance, in Ireland, we mentioned that the European Constitution was not successful is because the communities did not enforce this via referendum. What can they do? What can the constitutional courts do? The ultra vires is when the European Union goes beyond its mandate. So a constitutional court can say that that it cannot be implemented, or if it's against a member state's act or legislation. So we have to also mention that the Solange 1 and Solange 2 decisions of the German Constitutional Court go directly against the European Court's decisions and the European Court's verdicts, such as the Costa NL decision or Van der Loos, where the Luxembourg Court said that the union legislation having a primate or primary effect, but the German Constitution Court did not confirm this primacy, such as in a case of a central bank which would finance the Mediterranean countries from a secondary source. And the Constitutional Court, the German Constitutional Court, said that these decisions cannot take effect, and this European legal practice cannot be implemented in Germany if it doesn't change its rulings. And knowing the European Central Bank's decision was adopted by the European Court of Justice by buying shares directly. Now, in France, the Conseil d'État and also the Italian and the Polish Constitutional Court confirmed this practice. The Hungarian Constitutional Court has not gone directly against the European Court of Justice, but we cannot exclude this happening in the future. We also have to state that the acquis communautaire's adoption and the legal harmonization at the time of accession in 2004. So the norms which are made now are more politicized and more divisive than the previous rulings. So I'm thinking about the temporary mandatory quota about migration and other similar suggestions. So it's by common language called the despotism or the tyranny of the European Union. So we have to say that the Union's decisions are not in line with the basic treaties, but are going in the direction of breaking integration. And finally, I have to also say what sort of perspectives do the member states in the respect of room to maneuver. It is quite obvious that it's not only through the constitutional courts, but similar to the British Prime Minister's suggestion, the red card. Now there is a yellow card, which is not really suitable for making these suggestions invalid. But it would be more than an indication. It would be like a barrier towards the European Union which would mean that the member states do not have to implement what the European Union says. Now, Denmark is an exception, and we cannot exclude that this kind of opt-out can be exercised. Now, I'd like to bring the attention to the spiral effect of more Euro principle trend, which is in the European Union today, not only for exercising joint legislation or joint rulings in respect of foreign policy, for instance, or taxation, but for instance, it wants to control the justice system as well by having the European Common Attorney's Department. So the spiral effect would be exercised here as well. So we can conclude quite obviously, if there was a European Attorney's Department, then there would be a situation whereby the member states would not be able to initiate cases, but the European Prosecutor's or Attorney's Office would have, or the courts would have, the right to initiate cases against European citizens. So these procedures would be done. So in summary, we can say that currently the federalist versus sovereign debate has not been decided yet. Now it seems to be a primacy of the former. Within the European Parliament, the communities are in more numerous numbers who want to have a federalist Europe. And perhaps we can still save the Fouché plan, de Gaulle's ideas, and go against the Spark plan, which today is represented by President Macron or Angela Merkel. So in order for issues to be decided not on the banks of the Spree or the Seine, and according to Spiegel, the kind of under-the-table democracy, we need to have the European Council to preserve its integrity and to have the unanimous vote within the Council. Thank you very much for your attention.